Right, let's go ahead and call the Senate back to order. Sergeant Arms will please secure the chamber doors. Members, please take your seats. Madam Clerk, please call the roll.
Mr. President.
All right, Senators, we will substitute the the invocation from earlier to the second session invocation. Has everyone recorded their presence, slowly but surely? So the clerk will take the call. With 42 members in the chamber and a quorum being present, the Senate of Maryland is again back in session. Let's see. Do we have any introductions before we jump into things? Any notes or details? Appears not. In that case, so be considered the reading of the journal from the prior legislative session. We will jump right into finance, into the Finance Committee. We're going to go to report number 22. 22. Clerk will read the first bill.
Senate Bill 530, Senator Heddleman, Aging in Place Programs, Grants, Multi-Generational Third Places, Village Multi-Generational Third Places Act. Favorable.
Recognized Senator from District 8 is the floor leader.
Thank you, Mr. President. SB 530 authorized the Maryland Department of Aging to make grants to nonprofit organizations and area agencies on aging to support social connection for individuals in aging in place programs through events and gatherings at multi-generational third places. There are no amendments. I move the adoption of the favorable committee report.
Floor leader moves to the adoption of the favorable committee report. Any discussion? Any objections? Without objection, the favorable committee report is adopted. Are there any amendments to the bill or its title? Seeing none, Senate Bill 530 is hereby ordered, printed for third reading. Clerk, read the next bill.
Senate Bill 731, Senator M. Washington, Human Services, Maryland Statewide Independent Living Council, legal status, favorable.
Recognize the senator from the 22nd as the floor leader.
Thank you, Mr. President. This bill clarifies that the Maryland Statewide Independent Living Council is a tax-exempt body politic and corporate. There are no amendments. I move the adoption of the favorable committee report.
All right, floor leader moves for the adoption of the favorable committee report. Any discussion? Any objections? Without objection, the favorable committee report is adopted. Are there any amendments to the bill or its title? Seeing none, Senate Bill 731 is hereby ordered, printed for third reading. Clerk, read the next bill.
Senate Bill 809, Senator King, supporting our caregiver infrastructure program feasibility study, favorable with 2 amendments.
Recognize the senator from Montgomery County as the floor leader.
Thank you, Mr. President. Senate Bill 809 requires the Office of the Comptroller, with assistance from the Department of Human Services, to study and make recommendations on the feasibility of establishing and operating a supporting our caregiver infrastructure program to a caregiver for each dependent for whom a caregiver provides care. There are 2 amendments. Amendment 1 is technical. Amendment 2 changes the entity conducting the study from the Office of the Comptroller to University of Maryland College Park. The bill received a unanimous favorable report, Mr. President. I move the amendments and the adoption of the favorable committee report.
Floor leader moves for the adoption of the 2 committee amendments and the favorable committee report. On the amendments, any discussion? Any objections? Without objection, the 2 committee amendments are adopted. Question on the amended report. Any discussion? Any objections? Without objection, the amended report is adopted. Are there any further amendments to the bill or its title? Seeing none, Senate Bill 809 is hereby ordered, printed for third reading. Clerk, read the next bill.
Senate Bill 860, Senator Zucker, Department of Aging, Aging Resilience Fund establishment, favorable with 1 amendment.
Recognize the senator from Anne Arundel as the floor leader.
Thank you, Mr. President. Senate Bill 860 establishes the Aging Resilience Fund as a special non-lapsing fund to support implementation of the Maryland Department of Aging's mission. The fund may be used for administrative expenses that align with the department's mission, partnership development, and program services or activities within the department. There is 1 amendment. The amendment specifies that certain money received by the fund is supplemental and not meant to replace other appropriations, prohibits the governor from reducing an appropriation to the fund in the state budget, and requires an annual report on deposits and expenditures made to the fund in the preceding year. The bill passed the committee unanimously, and I move the amendment and the adoption of the favorable committee report.
Floor leader moves to the adoption of the 1 committee amendment and the favorable committee report. On the amendment, any discussion? Any objections? Without objection, the one committee amendment is adopted. Question now on the amended report. Any discussion? Any objections? Without objection, the amended report is adopted. Are there any further amendments to the bill or its title? Seeing none, Senate Bill 860 is hereby ordered printed for third reading. Clerk, read the next bill.
Senate Bill 910, Senator Mouts, Health Insurance Graduate Level Clinical Interns Required Reimbursement, favorable with one amendment.
Recognizing the bill sponsors, the floor leader.
Thank you, Mr. President. Senate Bill 910 requires certain health insurance policies that provide reimbursement for a service within the lawful scope of practice of a licensed graduate professional counselor, licensed master social worker, or licensed psychologist to reimburse for the service provided by a graduate level counseling clinical intern, graduate level social work clinical intern, or graduate level psychology clinical intern under specific circumstances. There's one amendment. The amendment clarifies that the services provided by a graduate level counseling clinical intern are reimbursable when provided under the supervision of a board approved supervisor. I move the amendment and the adoption of the favorable committee report.
Floor leader moves for the adoption of the one committee amendment and the favorable committee report. On the amendment, any discussion? Any objections? Without objection, the one committee amendment is adopted. Question now on the amended report. Any discussion? Any objections? Without objection, the amended report is adopted. Are there any further amendments to the bill or its title? Seeing none, Senate Bill 910 is hereby ordered printed for third reading. Clerk, read the next bill.
Senate Bill 972, Senator Hayes, Baltimore City, 40th Alcoholic Beverage District, Class B beer, wine, and liquor licenses, favorable with two amendments.
Recognize the bill sponsors, the floor leader.
Thank you, Mr. President. Senate Bill 972 authorizes the Baltimore City Board of License Commissioners to issue in the 40th Alcoholic Beverages District a Class B beer, wine, and liquor license for a restaurant on the odd side of the 1000 block of West Baltimore Street, and a Class A Class B beer, wine, and liquor license for a restaurant on the even side of the 800 block of North Charles Street. There are two amendments. Amendment number 1 is technical. Amendment number 2 requires the board to waive any requirements that alcohol beverage sales may be made only to members and guests of members for a Class C beer, wine, and liquor license in the 1200 block of Utah Place, and alters the boundaries in which certain alcoholic beverage license holders in the 40th District Alcoholic Beverage District may not sell alcoholic beverages during certain hours. There's no fiscal impact. I move the amendments and adoption of favorable committee report.
Floor leader moves to the adoption of the two committee amendments to the favorable committee report. On the amendments, any discussion? Any objections? Without objection, the two committee amendments are adopted. On the amended report, any discussion? Any objections? Without objection, the amended report is adopted. Are there any further amendments to the bill or its title? Seeing none, Senate Bill 972 is hereby ordered printed for third reading. Let's go to Finance Report 23. Clerk, read the first bill.
Senate Bill 555, Senator Hayes, Health, Dementia Services, and Brain Health Program Clinical Toolkit, favorable with two amendments.
Recognizing the Vice Chair of the Committee is the floor leader.
Thank you, Mr. President. Senate Bill 555, as amended, establishes the Dementia Services and Brain Health Program in the Maryland Department of Health to lead the state's public health efforts relating to brain health and dementia. By October 1st, 2027, the department, in partnership with certain organizations with expertise in Alzheimer's disease or related dementia, must establish and maintain and provide a resource toolkit for dementia care for healthcare providers. By January 1st, 2028, and annually thereafter, the department must review and update the information to the toolkit. Amendment number 1 is technical. Amendment number 2 alters the name of the toolkit from the clinical to the provider resource toolkit as described, delays the date by which the toolkit must be established, and specifies that the toolkit shall be comprised of existing materials and expertise or obtained through partnerships with other organizations as necessary. There was no opposition at the committee hearing. I move the amendments and adoption of favorable committee report.
Floor leader moves for the adoption of the two committee amendments and the favorable committee report. On the amendments, any discussion? Any objections? Without objection, the two committee amendments are adopted. Question now on the amended report. Any discussion? Any objections? Without objection, the amended report is adopted. Are there any further amendments to the bill or its title? Seeing none, Senate Bill 555 is hereby ordered printed for third reading. Clerk, read the next bill.
Senate Bill 757, Senator Rosapek, Consumer Protection, Disclosure of Tariffs and Local Sourcing, favorable with two amendments.
Recognize the Senator from Anne Arundel as the floor leader.
Thank you, Mr. President. Senate Bill 757, as amended, requires Commerce to develop and maintain a searchable online database to be known as the Maryland Local Sourcing Portal, to connect businesses in the state with local sources for tariff-impacted goods and other supplies. By December 31st each year, Commerce must report to the General Assembly on the use and effectiveness of the portal. Amendment 1 is technical. Amendment 2 strikes certain tariff disclosure requirements for sellers of tariff-impacted goods. I move the amendments and adoption of the favorable committee report.
Floor leader moves for the adoption of the two committee amendments and the favorable committee report. On the amendments, recognize the senator from District 7.
Thanks. Got a couple questions on this, but actually, you know what? Instead of wasting time tonight, let me just lay the bill and amendments over. That way I can kind of read up on it tonight and see if I have more questions, not burn up time, Mr. President.
Senator's motion is in order. The bill and the amendment will lie over under the rule. Clerk, read the next bill.
Senate Bill 772, Senator Ferguson, Maryland Department of Health, Employment, Training, and Opportunity Database, favorable.
Recognizing the senator from Montgomery County is the floor leader.
Thank you, Mr. President. Colleagues, Senate Bill 772 requires the Maryland Department of Health to coordinate with specified entities to develop and maintain an employment, training, and opportunity database to provide individuals in the state with assistance in finding employment, training, and other opportunities that may enable them to become eligible and or maintain eligibility for Medicaid and SNAP. The Maryland Department of Labor, the Secretary of Human Services, and the Department of Service and Civic Innovation must each establish a process through which a person may recommend a vocational, workforce training, or job placement program for inclusion in the database. Mr. President, there are no amendments. There was no opposition at the committee hearing. The committee was unanimous in its favorable report. I move the adoption of the favorable committee report.
All right, floor leader moves for the adoption of the favorable committee report. Any discussion? Any objections? Without objection, the favorable committee report is adopted. Are there any amendments to the bill or its title? Seeing none, Senate Bill 772 is hereby ordered printed for third reading. Clerk will read the next bill.
Senate Bill 792, Senator Lamb, Hospitals Immigration Enforcement Action Policy Requirement, favorable with two amendments.
Recognize the bill sponsor is the floor leader.
Thank you, Mr. President. Senate Bill 792, as amended, requires a hospital to adopt a policy describing the protocol of the hospital when there is an immigration enforcement action at the hospital that is consistent with guidance provided by the Office of the Attorney General. The policy must be available to all hospital staff members, and the hospital must annually provide training to staff to ensure understanding of the policy. There are two amendments. The first is technical. The second amendment strikes provisions regarding the HSCRC to develop a model policy and instead requires hospitals to adopt their own policies as described. There was no opposition at the committee hearing. Move the adoption of the amendment, two committee amendments in the favorable committee report.
Floor leader moves to the adoption of the two committee amendments in the favorable committee report. On the amendments, any discussion? Any objections? Without objection, the two committee amendments are adopted. Question now on the amended report. Any discussion? Any objections? Without objection, the amended report is adopted. Are there any further amendments to the bill or its title? Seeing none, Senate Bill 792 is hereby ordered printed for third reading. Clerk, read the next bill.
Senate Bill 869, Senator A. Washington, Economic Development, Maryland Workforce Launch Pilot Program Establishment.
Recognize the senator from the 22nd. Bill sponsors the floor leader.
Thank you, Mr. President. This bill establishes the Maryland Workforce Launch Pilot Program within Commerce to provide customized, no-cost workforce training as a business attraction tool to recruit strategic industries and qualified business entities to the state. Commerce must partner with no more than 2 community colleges to deliver training services and must distribute funds to a partner community college to cover the direct costs of developing and delivering the training. Any curriculum, manuals, or instructional materials developed under the program are owned by the community college. The bill sunsets September 30th, 2029. There are no amendments. I move the adoption of the favorable committee report.
All right, floor leader moves to the adoption of the favorable committee report. Any discussion? Any objections? Without objection, the favorable committee report is adopted. Are there any amendments to the bill or its title? Seeing none, Senate Bill 869 is hereby ordered printed for third reading. Clerk will read the next bill.
Senate Bill 905, Senator Zucker, Maryland Technology Development Corporation, Maryland Advanced Manufacturing Grant Program established.
Recognize the senator from Montgomery County as the floor leader.
Thank you, Mr. President. Colleagues, Senate Bill 905 establishes the Maryland Advanced Manufacturing Grant Program and related special fund. It's administered by the Maryland Technology Development Corporation, known as TEDCO. The purpose of the program is to support the growth of companies specializing in regenerative medicine and other advanced manufacturing. TEDCO must establish eligibility and evaluation criteria, as well as grant award procedures and amounts. Amendment 1 is technical and authorizes TEDCO's administrative costs to come from the special fund. There was no opposition at the committee hearing. I move the amendment and the adoption of the favorable committee report.
Floor leader moves for the adoption of the one committee amendment and the favorable committee report. On the amendment, any discussion? Any objections? Without objection, the one committee amendment is adopted. Question now on the amended report. Any discussion? Any objections? Without objection, the amended report is adopted. Are there any further amendments to the bill or its title? Seeing none, Senate Bill 905 is hereby ordered printed for third reading. Clerk will read the next bill.
Senate Bill 974, Caroline County Senators, Caroline County Alcoholic Beverages Inspector.
Recognize the senator from the 37th as the floor leader.
Thank you, Mr. President. Senate Bill 974 establishes that the inspector for the Caroline County Board of License Commissioners must be either an individual appointed by the board or the county codes administrator. It doesn't have to necessarily be that individual. They can appoint someone. There are no amendments. There's no fiscal impact. There was no opposition at the committee hearing. I move the adoption of the favorable committee report.
Floor leader moves to the adoption of the favorable committee report. Any discussion? Any objections? Without objection, the favorable committee report is adopted. Are there any amendments to the bill or its title? Seeing none, Senate Bill 974 is hereby ordered printed for third reading. All right, let's go to budget and taxation. We'll go to, actually, we're missing a number of B&T. Let's see, we've got, looks like everybody here from Triple E is here. Let's go to report number 15 out of Triple E. 15, 15, well, can't do that one either. Let's see. Who is here? Are we ready for 10? Let's do report number 10 out of budget and tax. Clerk will read the bill.
Senate Bill 28, Senator McCray, Arbitration Reform for State Employees Act of 2026, favorable with 2 amendments.
All right, recognizing the senator from the 45th as the floor leader.
Thank you, Mr. President. Senate Bill 28, as amended, alters the statutory collective bargaining process for state employees by establishing binding arbitration in the event of an impasse in negotiations. In addition, it requires the selection of a neutral arbitrator to oversee all aspects of collective bargaining. The bill also includes the proposed constitutional amendment that requires the governor to include in the annual budget bill submission to the General Assembly the appropriation necessary to implement and fund all terms of the Memorandum of Understanding or binding arbitration. Mr. President, there are 2 amendments. Amendment number 1 makes technical changes to the title, and amendment number 2 excludes institutions of higher education from the arbitration process, excludes pension benefits from the scope of collective bargaining, specifies information to be submitted with an arbitration decision. Move favorable of the committee report.
All right, floor leader moves for the adoption of the 2 committee amendments and the favorable committee report. On the amendments, any discussion? Any objections? Without objection, the 2 committee amendments are adopted. Question now on the amended report. Any discussion? Any objections? Without objection, the amended report is adopted. Are there any further amendments to the bill or its title? Seeing none, Senate Bill 28 is hereby ordered printed for third reading. Let's do report number 11 out of budget and taxation. Clerk will read the first bill.
Senate Bill 466, Senator King, income tax credit for physician preceptors in areas with healthcare workforce shortages, alterations, favorable with 2 amendments.
Recognize the majority leader. The bill sponsor is the floor leader.
Yes, thank you, Mr. President. Senate Bill 466 expands eligibility for the state income tax credit for physician preceptors in areas with healthcare workforce shortages to include physicians who serve in a preceptorship program authorized by an accredited out-of-state medical school. The bill also reduces the minimum number of community-based clinical training hours for each of the minimum required 3 rotations from 100 to 90. There are 2 committee amendments. Amendment number 1 makes changes to the purpose paragraph. Amendment number 2 limits the excess amount of tax credit certificates that the Department of Health may carry forward and issue in subsequent taxable years. I move adoption of the 2 amendments and the favorable committee report.
Floor leader moves for the adoption of the 2 committee amendments and the favorable committee report. On the amendments, Any discussion? Any objections? Without objection, the two committee amendments are adopted. Question is on the amended report. Any discussion? Any objections? Without objection, the favorable committee report as amended is adopted. Are there any further amendments to the bill or its title? Seeing none, Senate Bill 466 is hereby ordered printed for third reading. Clerk will read the next bill.
Senate Bill 557, Senator Bidel, Gaming, Definition of Own, Alterations, favorable with one amendment.
Recognizing the majority leader.
Can I lay this bill over until the end of the calendar?
Mind if we special order it?
Special order it till the end of the calendar. How's that?
Great. Let's say, can we do, let's say, end of the day? End of the evening, does that work?
Yeah, to the end of the evening.
Any
That's fine.
objections?
Thank
All right.
you.
Without objection, so ordered. Clerk, read the next bill.
Senate Bill 704, Senator Mounts, Maryland Estate Tax Qualified Agriculture Property Transfer to Limited Liability Company, favorable with one amendment.
Recognize the majority leader.
Yes, Mr. President, I'd like to special order this bill until the end of the evening.
Excellent. Any objections? Without objection, so ordered. Missing that. All right, let's go to Tripoli calendar 16, report number 16, 16. Clerk will read the first bill.
Senate Bill 35, Senator Jackson, State Designations, Natural State Science Museum, Natural History Society of Maryland, favorable with two amendments.
All right. Recognizing Senator from the 27th as the floor leader.
Thank you, Mr. President. Senate Bill 35, State Designations, State Natural Science Museum, National History Society of Maryland is favorable with two amendments. This bill designates the National History Society of Maryland as a state national science museum. There are two amendments. The amendments are all technical. Please move the favorable report with the two amendments.
Floor leader moves to the adoption of the two committee amendments and the favorable committee report. On the amendments, any discussion? Any objections? Without objection, the two committee amendments are adopted. Question now on the amended report. Any discussion? Any objections? Without objection, the amended report is adopted. Are there any further amendments to the bill or its title? Seeing none, Senate Bill 35 is ordered printed for third reading. Clerk will read the next bill.
Senate Bill 166, Senator Bailey, Shellfish Aquaculture Penalty Suspension or Revocation of Permit or Registration Card, favorable with two amendments.
Recognize the Senator from the 35th as the floor leader.
Thank you, Mr. President. Senate Bill 166 allows the Department of Natural Resources to suspend or revoke a shellfish aquaculture harvester permit or registration card of a person engaged or working in shellfish aquaculture for knowingly committing specified offenses similar to authority the department has with respect to those engaged in the public oyster fishery. There are two committee amendments. The first one is technical. The second amendment alters the offenses covered by the bill and establishes a process for an individual whose aquaculture lease is terminated in accordance with the bill to remove their gear from the lease site and transfer the lease to another person. The bill passed unanimously in committee. I'd like to move the two amendments and ask for adoption of the favorable committee report.
Floor leader moves to the adoption of the two committee amendments and the favorable committee report. On the amendments, any discussion? Any objections? Without objection, the two committee amendments are adopted. Question now on the amended report. Any discussion? Any objections? Without objection, the amended report is adopted. Are there any further amendments to the bill or its title? Seeing none, Senate Bill 166 is hereby ordered printed for third reading. Clerk, read the next bill.
Senate Bill 189, Senator Lewis Young, Municipalities Open Drainage Inlets Required Grading Systems, Mason's Law, favorable with two amendments.
Recognizing Vice Chair of the committee is the floor leader.
Thank you, Mr. President. Last July 31st, Mason Kearns, just 13 years old, was playing with his brother, and there was a storm drain that he got sucked into and later died. This was not unique. Dozens of people die this way every year. This bill, as amended, would require municipalities to take an inventory and then for any new construction, make sure that there is grading to make sure that no person or pet gets sucked in inadvertently. The bill passed unanimously. Again, there were 2 amendments. The first one is technical. The second one narrowed the bill and made it prospective and added the inventory. Move adoption of the 2 committee amendments and the favorable committee report.
Floor leader moves to the adoption of the 2 committee amendments and the favorable committee report. On the amendments, any discussion? Any objections? Without objection, the 2 committee amendments are adopted. Question now is on the amended report. Any discussion? Any objections? Without objection, the amended report is adopted. Are there any further amendments to the bill or its title? Seeing none, Senate Bill 189 is hereby ordered printed for third reading. Clerk will read the next bill.
Senate Bill 242, Senator Simon Ayer, Modernization Civil Relief for Service Members Act, favorable with 2 amendments.
Recognizing the bill sponsor is the floor leader.
Thank you, Mr. President. Last week we passed a similar bill for the foreign service members. This bill authorizes an active service member or an active service member's spouse who relocates to the state due to orders for service and holds a license issued by another jurisdiction to practice under that license within Maryland if the individual submits an application including specified documentation and satisfies other criteria. If an active service member or spouse is authorized to practice under the bill's provision, the individual may practice only in the discipline and scope of practice allowed by the license in the other jurisdiction. And the licensing authority in the state may not require another license unless the individual seeks to practice outside the authorized discipline or scope of practice. The bill also makes conforming changes and modifies eligibility requirements for certain expedited license requirements. There were 2 amendments. The first is technical. The second clarifies that a service member or their spouse, if they practice their occupation in the state, are subject to the same oversight authority and disciplinary authority as every other licensee, and makes technical changes. It passed Triple-E and Finance unanimously. I move the adoption of the amendment and the favorable committee report.
Floor leader moves to the adoption of the 2 committee amendments and the favorable committee report. On the amendments, any discussion? Any objections? Without objection, the 2 committee amendments are adopted. Question now on the amended report. Any discussion? Any objections? Without objection, the amended report is adopted. Are there any further amendments to the bill or its title? Seeing none, Senate Bill 242 is hereby ordered printed for third reading. Clerk, read the next bill.
Senate Bill 266, Senator Brooks, Local Government Regulatory Powers, Regulation of Tree of Heaven, favorable with 2 amendments.
Recognizing the bill sponsor is the floor leader.
Thank you, Mr. President. Colleagues, as amended, Senate Bill 266 authorizes the governing body of a county or municipality to regulate through an ordinance listed invasive trees and trees of heaven, including by prohibiting a person from selling or planting such trees or allowing the trees to grow on the person's property. The bill authorizes the governing body of a county or municipality to establish a bounty or native tree replacement program to incentivize the removal and eradication of trees of heaven and listed invasive trees. The bill also authorizes the governing body of a county or municipality to provide for the enforcement of an ordinance adopted under this bill. This is enabling legislation. There are 2 committee amendments. Amendment number 1 is technical. Amendment number 2 alters definition, expand the scope of the bill to allow local jurisdiction to regulate certain listed invasive trees, authorizes the establishment of a local native tree replacement program, and establishes criteria for identifying and removing invasive species under a program adopted under this bill. There was no opposition, and the bill passed the committee unanimously. I move the 2 committee amendments and the adoption of the favorable committee report.
Floor leader moves to the adoption of the 2 committee amendments and the favorable committee report. On the amendments, any discussion? Any objections? Without objection, the 2 committee amendments are adopted. Question now on the amended report. Any discussion? Any objections? Without objection, the amended report is adopted. Are there any further amendments to the bill or its title? Seeing none, Senate Bill 266 is hereby ordered printed for third reading. Clerk, read the next bill.
Senate Bill 267, Senator Brooks, Land Use, Residential Housing, Oversight, Regulation, Taxation, Building Affordably, and My Backyard Act, favorable with 3 amendments.
Recognizing the bill sponsor is the floor leader.
Thank you, Mr. President. Colleagues, as amended, Senate Bill 267 requires the Department of Housing and Community Development to establish a registry of certain corporate owners of rental properties in the state and to provide the contact information for registered entities to units of local government on request. The bill also authorizes a local jurisdiction, after making a determination that it has a shortage of affordable housing, to establish an administrative process to review, approve, modify, or deny housing development projects applications. There are 3 committee amendments. Amendment number 1 is technical. Amendment number 2 narrows the application of the registration requirements to apply only to property owners that rent or intend to rent properties, and exempts property owners in counties that have a local registration requirement. Amendment number 3 strikes provision of the bill related to housing production targets, sales of single-family residential properties, regulatory and construction certainty, local projects design guideline and pre-approved permit application processes, housing sensitivity, taxes and fees, and mandate reports. I move the adoption of the 3 committee amendments and the favorable committee report.
Floor leader moves for the adoption of the 3 committee amendments and the favorable committee report. On the amendments, recognize the minority leader.
Thank you, Mr. President. If the floor leader would yield for a question or 2.
Senator, may proceed.
Thank you very much.
5, 4, 6.
I see that this bill has been pretty dramatically amended, and know at the time of the introduction of the bill, there was some opposition, namely from the builders and NAIOP. Under the bill now as amended, did that opposition go away?
Yes, it did.
Okay, and so we talked about a bill earlier today that dealt with trying to get more with the certainty of development rights and the process of applications. How does this bill differ from that we talked about earlier? What does this bill do specifically now that it's been amended?
Okay.
This is just a registry of responsible.
Yeah. This is just a responsible owner registry, and it makes it possible for any and it's an administrative process for review and authorization. Yes.
So the registry that's being set up now is by DHCD?
Yes, it is. Right.
Okay, and then that registry, the information will be, what's the information that they're going to be carrying?
Okay, the information that's going to be carried will be the name of the person who's renting the particular property, and it can be provided, name and address, and it'll be provided to the local government upon request. And it's done on an annual basis.
Okay, so this just refers to rental properties then? Is that what you said?
Yes, properties that are being rented or are set up for rental, yes.
Okay, so does it deal with, again, as amended, because again, there's a lot of amendments, as amended now, does it deal with new construction and how to promote new construction, or is it now just basically looking at an inventory of existing properties and trying to find a way to rent those?
Yeah, it's there are 2 pieces. There's the rental property registry,
right,
and the authorization of administrative review of residential development projects.
Okay, and who's doing that review? Is that at the local level that review occurs? Because
yes, it is at the local level.
Okay, because that was like what we talked about with the Housing Certainty Act earlier today, of making sure that those applications were getting pushed through in a timely manner and then having to be determined incomplete within a certain time. Mm-hmm. Is this similar to that, or?
Let me confirm.
Okay.
It's a bit complicated, and not to answer your question properly, it's not really. Yes.
I'm sorry.
Not really.
Not really. So
yes.
It's different than that. So
yes, it is.
So the application, your process that you're talking about is, again, is that for new development and construction or the rental inventory?
It's for new development. Yes.
Okay. All right. Okay. I appreciate the responses. Thank you.
You're quite welcome, sir.
Thank you, Mr. President.
Thank you, Senator. All right, question remains on the 3 amendments. Any further discussion? Any objections? Without objection, the three committee amendments are adopted. Question now is on the amended report. Any discussion? Any objections? Without objection, the amended report is adopted. Are there any further amendments to the bill or its title? Seeing none, Senate Bill 267 is hereby ordered printed for third reading. Clerk, read the next bill.
Senate Bill 270, Senator Carrozza, Public Service Commission, full cost and benefit analysis of source of electricity generation, favorable with one amendment.
Recognize the bill sponsor as the floor leader.
Thank you, Mr. President. Senate Bill 270 requires the Public Service Commission to conduct a full cost and benefit analysis of sources of electricity generation in the state as it pertains to natural gas, nuclear, offshore wind, and energy storage as specified. By December 1st of 2027, the Public Service Commission must report its findings and recommendations to the Senate Committee on Education, Energy, and the Environment and the House Environment and Transportation Committee. There is one amendment. The amendment defines levelized full system cost of electricity and adds solar combined with energy storage as items to be reviewed under the provisions of the bill. Senate Bill 270, as amended, passed out of committee unanimously. I move adoption of SB 270, favorable with amendment.
Floor leader moves for the adoption of the one committee amendment and the favorable committee report. On the amendment, any discussion? Any objections? Without objection, the one committee amendment is adopted. Question now is on the amended report. Any discussion? Any objections? Without objection, the amended report is adopted. Are there any further amendments to the bill or its title? Seeing none, Senate Bill 270 is hereby ordered printed for third reading. Clerk, read the next bill.
Senate Bill 588, Senator Simon Narrow, Natural Resources, Complementary Fishing and Hunting Licenses, alterations, favorable with two amendments.
Recognizing the bill sponsor as the floor leader.
Thank you, Mr. President. This bill modifies provisions authorizing or requiring DNR to issue complimentary angler license, Chesapeake Bay and coastal sport fish license, recreational oyster license, and hunting license to specified individuals, with the changes establishing consistency among the provision. The bill also requires the department to compile specified statistics on hunting license and establishes the commemorative lifetime hunting license that were issued December 2011 as non-transferable. There were two committee amendments. The first is technical. The second strikes the provisions that would have extended complimentary recreational oyster license to various categories to non-residents and makes minor clarifying changes. The amendment also clarifies certain existing caps on the number of complimentary angler license and hunting license that may be offered to certain non-resident government officials. There's no fiscal impact, no opposition, and then passed unanimously. I move the amendment in the favorable committee report.
Floor leader moves to the adoption of the two committee amendments and the favorable committee report. On the amendments, any discussion? Any objections? Without objection, the two committee amendments are adopted. Question now is on the amended report. Any discussion? Any objection? Without objection, the amended report is adopted. Are there any further amendments to the bill or its title? Seeing none, Senate Bill 588 is hereby ordered printed for third reading. Clerk, read the next bill.
Senate Bill 872, Senator M. Washington, reduction of lead risk in housing, rental dwelling unit definition, favorable.
Recognizing the bill sponsor as the floor leader.
Thank you, Mr. President. Senate Bill 872 closes a gap in our current law that leaves some tenants without lead safety protections. The bill clarifies that the definition of a single room and occupancy that are shared arrangements. There's some terminology that refers to independent, and it's somewhat confusing. And so what this bill does then is to clarify that definition. There are no committee amendments. The bill passed unanimously. So I ask for the adoption of a favorable committee report.
Floor leader moves to the adoption of the favorable committee report. Any discussion? Any objections? Without objection, the favorable committee report is adopted. Are there any amendments to the bill or its title? Seeing none, Senate Bill 872 is hereby ordered printed for third reading. Let's go back I think we have our floor leader number 15, Education, Energy, and the Environment, report number 15. Clerk will read the bill.
Senate Bill 311, the President, Education, the Blueprint for Maryland's Future, revisions, favorable with two amendments.
Recognizing the senator from the 23rd as the floor leader.
Thank you, Mr. President. Colleagues, this bill makes several alterations to the Blueprint for Maryland's funding.
The changes include repealing a certain technology report, extending by 1 year through FY 2027 the current low-income student count or compensatory education enrollment methodology for the compensatory education aid program and concentration of poverty grant program, making permanent local flexibility in the use of certain concentration of poverty grant funding, altering teacher licensure qualifications, altering the date by which an individual must have earned a national board certification to qualify as a licensed principal, extending from the end of fiscal 2027 to the end of fiscal 2030 the time frame during which State Board of Education and the Accountability Implementation Board may, in consultation with local school systems, limit the number and types of courses that a student duly enrolled at a student's public high school and at an institution of higher education may enroll during the school year, alters the definition of wraparound services, repeals the Career and Technical Education Skills Advisory Committee, and makes clarifying changes about the CTE committee structure. There are 2 committee amendments. The first one is technical. The second amendment strikes the repeal of the technology report from the bill, alters certain teacher certification provisions to repeal a requirement that a portfolio assessment be nationally accredited, allows effective teacher evaluations from school or system report, requires MSDE to suspend operations of the expert review team program for the 2026-2027 school year, requires the AIB and MSDE to identify a methodology for counting students from low-income households to calculate the compensatory education aid funding formula. The process must be collaborative and transparent and include consultation with the Department of Budget and Management and the Department of Legislative Services. Fiscal impact is $228.5 million. I move the 2 committee amendments and the favorable committee report.
Floor leader moves for the adoption of the 2 committee amendments and the favorable committee report. Recognize Senator from District 6 on the amendments.
Thank you, Mr. President. Just want to talk about this for a moment, especially the fiscal note, if I could.
Senator may proceed.
It says right here the state effect. It says, Mr. President, the state expenditures in support of public schools increase, as was stated, by $22.8 million. That's state. Also, Mr. President, and it says it's a mandate, of course. It says local schools, also there's increase in expenditures as well. And knowing this is a mandate, not just for the state, but also for the locals, Mr. President, I'm just wondering, why wasn't this a dual bill, first of all? And if we could, I'd like to maybe revert this back to committee and go to budget and tax. I believe we haven't had the opportunity in budget and tax to look at this, to see the amounts that are mandated in the state and in the local government, Mr. President.
All right, the senators made a motion to recommit the bill to committee. Let's hear from the floor leader on the motion.
Mr. President, I asked the same question. I don't know why B&T was not a part of the bill, but we do know, if I need to explain the fiscal impact, the current law established a method for counting students from low-income families for purposes of calculating the compensatory educating funding, and the current method is subject to termination beginning in 2027. The Governor's Office of Children undertook a neighborhood indicator of poverty and researched different methods of counting students from low-income families for the purpose of calculating that compensatory education funding formula. The report was submitted to AIB to make recommendations for next steps, and the report presented multiple alternatives, which resulted in most local school systems receiving less money than they currently do. The current law has a hold harmless provision that prevents local school systems from receiving less money than they have been receiving in prior years. The bill also includes a 1-year extension of that hold harmless provision to allow MSDE and AIB to identify an appropriate methodology for accurately counting low-income students by the end of the year. Mr. President, that's all I can say about the fiscal impact. I have no leaning towards whether or not it goes back to B&T or not.
If I could, Mr. President?
Let's see, the question was on the motion to recommit. Let's see, are there any senators who have not yet spoken who wish to speak? On the motion, recognize Senator from District 6.
Thank you, Mr. President. As we have had many bills in our committees and in committees, they have been dual at times, as you know, Mr. President. We've had myself representing budget and tax and finance, budget and tax and other committees. And we tried to do the responsible thing as the Senate. And I think we've done that well. But I think this is one bill maybe that just slipped by. And I think the responsible thing to do is make sure that budget and tax has the opportunity just to discuss, which we haven't, these mandates of over $22.5 million for the state, and as well the locals, which now have been given more responsibility in the blueprint and the revision here. So I press the motion, Mr. President.
Mr. President?
Yes, recognizing the floor leader.
We did consult with the chair of B&T, and since he has arrived, I'm more than welcome to give him some time.
We'll yield to the chair.
Thank you, Mr. President, and I think I can catch up here. What we talked about was a multi-year process that was presented to us, 1 year, 2 year, 3 years. And ultimately, the recommendation that we left was a 1 year recommendation. And the reason by that is simply about how to think about, as I catch my breath from running up the stairs, to think about what we have ahead of us. And of course, as we've discussed many times yesterday and other times about how we have to think about the blueprint, we may have to think about it in very different light. And so it was my opinion that doing it beyond 1 year would in fact sort of lock us into multi-year, which would go past the time of the evaluation, the 5-year evaluation and our further consideration of what we should be doing with the blueprint. So it was really, yes, move forward, but also take a little bit of a pause from going all the way in on this particular issue.
All right. Let's hear from the senator from Baltimore City, Baltimore County on the motion.
Again, thank you, Mr. President. In some ways, I didn't have an opportunity to be a part of the discussion during the period last week. However, I was happy to see that the bill placed our committee as the primary and the sole in this case. Because, Mr. President, ultimately we're talking about our policy having to do with education and what those priorities are. And frankly, over the last couple of years, our thoughts and priorities and policies about what type of public education we're going to have in the state of Maryland has been driven primarily by a fiscal debate. And so I believe this 1 year plan that was negotiated with the chair is a good compromise to really have us think about what do we want to do in public education, what has happened over the last 5 years since the passage of the blueprint for Maryland's future that will allow us to make the necessary changes, both fiscally and from a policy perspective, to accommodate what our goals are and responsibilities are as a state of Maryland, but also do that in a fiscally responsible way. And again, uniting both our fiscal and our policy responsibilities. So I guess I'm speaking against the motion to recommit, asking the body to trust that we have come to a reasonable and timely solution for addressing both the short-term needs for change as well as looking forward to some necessary comprehensive adjustments to the blueprint for Maryland's future.
Thank you, Senator. Just to clarify, I want to make sure that we had it correct. I was moving too quickly. It wasn't a motion to recommit. It was a motion to commit to a particular committee. So we just want to make sure that that was the correct motion that was made. Recognize the minority leader on the motion.
Thank you very much, Mr. President. On the motion, if the budget chair would just respond to a question, please. He's on the phone. I understand that this is obviously the governor's bill, and I just wanted to see, did the governor's budget accommodate the $228 million.
Yeah, I was just going to get to that, actually.
Okay.
Yes. Yep. Senator may proceed.
Okay.
Yes, it's blueprint money. It's within the blueprint. It's covered. There's not an issue.
Thank you very much.
All right. Recognize back to the senator maker of the motion.
And I, in all respect, the chair, and I understand he has the understanding and the wisdom to move forward as the chair in our committee. I still believe as a committee and moving forward, we should have the opportunity to still look and reason about this and talk about it, maybe have the conversation, which I believe would be really important for all of us, Mr. President. So I strongly agree we should recommit this or commit this to budget tax, please. Thank you.
All right. Recognizing the senator from the 45th on the motion.
On a motion, Mr. President, I rise against the recommit. I tell you, I'm on B&T, but I've been following this issue very closely. I follow it very closely because it impacts the population that I represent from that standpoint. So no matter what committee it was in, I'm telling you that, like, I'm looking at how my folks are impacted, but more importantly, we've been having this issue in reference to how we count young people for years at this moment. I would have loved to see more of a long-term solution, but I do respect the solution that came out of the body of the committee with the 1 year, and we'll take a look at it when we have a larger conversation. But let me be clear, those that really care about this issue, those that are really impacted, have been following this issue no matter what committee is saying, because it's a very important bill.
Thank you, Senator. All right, questions on the motion. If there's no further discussion, all in favor of the motion say aye. Opposed, nay. And noes have it. We remain on the two committee amendments. Recognizing the minority whip on the amendments.
Thank you, Mr. President. I wonder if I could ask the floor leader from Triple E to yield for a couple more questions about the bill.
Certainly.
Senator may proceed.
Thank you. So one of the things I learned in the last couple of years as we wrestled with this locally in my area and in other places is just how complex the blueprint implementation, the AIB portion of it, it's very complicated, a lot of moving parts. And so a bill like this is obviously has a lot to it. Can you reiterate, we were discussing the year. It seems in some spots in the bill where the year, it's getting rid of a year entirely mentioned. I see 2027 is bracketed out in a couple of places. And in another spot, it's going to 2034, and I think that's about teacher accreditation. So just what's shifting? What does it mean? What's shifting and what does it mean, I guess?
Thank you. I want to thank the senator. So the AIB is responsible for fact-based, data-driven, informed decisions, and after looking at things for a period of time, they've suggested some modifications, right?
Mm-hmm.
One of them is the compensatory aid and concentration of poverty grants. And what they want to do is extend that for an additional year through 2027, okay? We talked about the career ladder for national board certification. And before a teacher may be licensed, as a principal, it's going to be delayed from July 1st, 2029 to July 1st, 2034, so that we can look at additional criteria for national board certification of teachers. There are modifications in here related to CTE skills, all right? And what we wanted to do, and the AI wants us to do, is to really look at the CTE criteria and work with the Governor's Workforce Development Board and develop and maintain a list of high skill, high wage, in-demand priority occupations for the state so that our graduates can remain competitive. Those are the primary considerations of the board. There's smaller things in there like wraparound services, which has been altered to include evidence-based academic interventions in addition to offering tutoring per current law. But these are tweaks that the AIB decided to make to further their goal of making sure they're putting metrics in place to tell how well we're doing. And when things are not working well, they're quickly able to go in and modify.
Yes, okay, good. That's helpful. I noticed under the compensatory ed section, there's the 2027, and there's one spot where it goes to 2028, which I assume just means they had to move that ahead by a year because of the other change. So it said for the fiscal year 2028 and each fiscal year thereafter, the greater of the number of students. That's now current law, the number of students eligible for free and reduced price meals from USDA or alternative state form for the prior year. So that basically it's just had to move that out a year also because of moving the 2027. I was just trying to understand that. And then there's also some information about community. Is there information about community schools in here? Or is it just the concentration of poverty grants that are in this bill with some tweaks?
What'd she say? Is that one and the same? They changed the definition of wraparound services.
Okay.
To include other academic interventions.
Okay. There's also a change here about accreditation. I guess that it's possible our state could create its own accreditation program because we're changing it from a national accreditation to either national or a state-created program. But I guess these are all AIB suggested changes.
That's correct.
Okay. Okay. And then the only other thing I guess I was curious about was the they're moving out it was going to be that beginning on July 1st of 2029, there was a requirement that a teacher be an NBC teacher before they could become a licensed principal, but they've moved that out to 2034. Is that just because basically we need a little more time to get that really up and rolling?
So that's a good question. So we're studying the issue and looking at additional things that would allow for that same certification. In other words, teachers who graduate from an institution of higher education in another state that hold a professional license. So the AIB is looking at all these other alternative ways, which is why we need more time to study.
Understood. Okay. No, I appreciate that. So going back to my colleague from Baltimore County, the reason for the extra money in this is it just because we're moving the years out? So it's not really new. Is it new money or is it just reallocating the money we had already planned to spend? I guess is my question. I don't know if that's...
No, good question. So what we're doing is increasing the formulas. We're increasing the formulas, and some things that were due to be sunset are going to go out further, which require additional money.
Which is more money. Okay. Okay. So because my understanding is there are some things here that help the locals as well. It's not just about more money from the state level, or is it?
More kids have been baked into the formula as well. More students.
Thank you. Does that increase the mandate on locals that they've got to come up with more money, or does it help the locals to get more money from the state because they're increased the number of children, or does it have no effect? And I'm just
it's a statutory formula. It's a statutory formula.
What impact does the formula change have?
Well, if we have more kids, then of course the funding levels go up.
From the state that flows down to the counties, or does it require the counties to now spend more as well?
It requires whatever the formula says.
The state share and the local share will both go up.
Okay. Thank you very much, Mr. President. Thank you. I'm glad we're looking at. There's some of these changes make sense based on my sort of thimbleful of knowledge about how this whole process works internally. Just trying to watch out that we don't add additional cost to the county as far as mandates while we're still figuring out, we're getting to this evaluation period. So I'll take a more close look at it, but I appreciate the answers. Thank you, Mr. Florida, and thank you, Mr. President.
Thank you.
Thank you, Senator. Senator from the 22nd on the amendments, or the bill, on the amendments in the report.
Thank you, Mr. President, and thank you. I just had a few questions. You know, I worked really hard on this piece of legislation, and I'm very interested in seeing some information about the expert review teams, and particularly why they're being suspended for a year, and then the funding is being transferred to another fund. If you could just explain that process and what that is.
Sure. The expert review team program, you know, they sent a team of expert educators assembled and trained to MSDE to low and high performing schools across the state to look at how the blueprint was being implemented and why the school is working well or maybe working insufficiently. And on review of the program, MSDE and AIB were unsatisfied that the program was working as intended and producing the results for the schools. So this one-year pause will give MSDE and AIB time to retool and restructure the program, and a report is due to the MGA, this body, on November the 1st of this year.
Thank you for that. I would just note, Mr. President, that I've made that comment here publicly here about these expert review teams and their selection process for what schools they go to, where they are, and how they review these schools and the parity in which they do it. I'm happy to see that we are pausing it to revisit the program so that it's actually impactful to those low-income schools that need it the most from these highly qualified professionals throughout the state. So I'm really happy to see that. My other question is about the funding piece, or the change to the study piece from the implementation board as well as the State Department on the calculation of compensatory education funding formula. Can you explain? I know they're going to go through a process of developing new, the new equation for the new formula to determine the number of students needed under this. Will they then report to the General Assembly that, and then the General Assembly will take up that and then codify it, or is it their recommendations become the final product?
No, so there's going to be a new methodology for counting the students, and that report has to come back to the General Assembly by the end of the year.
And the General Assembly will then have a decision to take that up or not. Is that right?
Well, yes, then the General Assembly has to make a decision.
Thank you very much.
Excellent. Thank you, Senator. Any further discussion on the amendments? On the amendments or the report? Recognize the minority leader on the.
Thank you, Mr. President. Whip and I were just discussing a couple things. Can motion to lay over the bill and the amendment under the rule?
The bill and the Senator's motion is in order. The bill and the amendment will lie over under the rule. All right, let's go to judicial proceedings, calendar number 1515. Clerk, read the first bill.
Senate Bill 12, Senator West, residential rental apartments air conditioning requirement, favorable with one amendment.
Recognizing the bill sponsor as the floor leader.
Thank you, Mr. President. This bill requires a landlord of residential rental units in apartment buildings with 4 or more individual dwelling units to provide air conditioning from June 1st through September 30th each year, as specified. Unless otherwise exempted by the bill, landlords are to provide air conditioning in residential rental units beginning June 1st, 2026 for newly constructed units and beginning October 1st, 2026 for existing units that undergo renovation that includes the replacement or substantial upgrade of electrical systems or heating systems. The bill applies prospectively only, does not have any effect on or application to any building construction or renovation for which the building permit is issued before the bill's effective date. Bill takes effect on June 1st of this year. There was one amendment. The amendment increases from 4 or more to 10 or more the number of individual dwelling units in an apartment building to which the bill's protections apply. It also deletes exceptions in the original bill, and it provides that the bill preempts and supersedes a local law, ordinance, policy, or regulation inconsistent with the air conditioning requirements of this bill. The bill has no fiscal note. I hereby move the adoption of the favorable committee report.
Floor leader moves for the adoption of the one committee amendment and the favorable committee report. On the amendment, any discussion?
President?
Yes, recognizing the minority leader on the one committee amendment and the report.
Thank you, Mr. President. The floor leader, would you just a question, please?
Senator may proceed.
Just trying to understand, you had said that the air conditioning must be provided from a period of time of June 1st to September 30th. Is this saying that the landlord then must carry the operation cost of that, or you're trying to?
There's nothing about who pays for it. The landlord, the lease can provide that the tenant pays electricity, or the landlord could pay it and just have a higher rent.
So why, I mean, are these to be temporary units? Or are they to be permanent?
After the bill takes effect, the landlord has to provide air conditioning, so long as the building has been built. Well, remember, the bill's divided into new buildings and existing buildings.
Right.
So if a new building is built after the bill takes effect, the building has to have air conditioning, and it has to be available each year from then on, from June 1st to October 1st.
If the building is an existing unit, then the landlord doesn't have to provide air conditioning until and unless the landlord engages in a substantial renovation of the building, the electrical system or the heating system. If there's a substantial renovation, the landlord has to include air conditioning in the renovation work, and from that point on, would have to provide the air conditioning from, what was it, June 1st till October 1st of each year from that point on.
Okay, I'm just trying to understand. We've had a lot of conversations about affordable housing and creating affordable housing. Doesn't this increase potentially the cost of renting?
Conceivably, but the whole thrust of this bill is we've reached the point with our annual summer heat domes where we have consecutive days of temperatures over 100 degrees. We've reached the point in Maryland where in the future, landlords who are building new units should have air conditioning in the units, and the air conditioning does have a minimum of 80 degrees. So the units could go up to 80 degrees, but the landlord must make sure the units are not hotter than 80 degrees on those extremely hot summer days.
That's completely different. So now you're stating that the landlord is in control of the temperature during
No.
a certain period of times, or just
No.
has to have a unit that's capable?
A unit that's capable.
Unit that's capable.
Right now, if the landlord controls the temperature in the building, the landlord has to make sure the temperature doesn't exceed 80 degrees. If each unit has its own temperature controls, or there's a window unit which is controlled by the tenant can let the temperature get hotter if the tenant wants.
Okay.
But the units must be sufficient to cool the unit down to 80 degrees if the tenant thinks more than 80 degrees is too hot.
Okay, and then back on the cost of this, again, this cost is all borne by the landlord to make the upgrades, or the potential new units must have air conditioning.
Well, the landlord would be responsible for providing the air conditioning, yes. Who pays for the air conditioning once it's running and there's an electricity cost? Again, if the unit has air conditioning units in the window, the bill is agnostic as to who pays for it. But if the lease doesn't require the tenant to pay for it, then the landlord would have to pay for it.
Well, that's the electricity. That's what you're talking about, the electricity to run the air conditioning. But the potential upgrades of existing buildings to include
that would be on the landlord's head.
Landlord, and then that would get passed down to the
presumably through higher rents.
To the higher rents. All right. Thank you very much. Appreciate it. Thank you, Mr. President.
Thank you, Senator. All right, on the amendment, any further discussion? Any objections to the amendment? Without objection, the one committee amendment is adopted. Question now is on the amended report. Any discussion? Any objections? Without objection, the amended report is adopted. Are there any further amendments to the bill or its title? Seeing none, Senate Bill 12 is hereby ordered printed for third reading. Clerk, read the next bill.
Senate Bill 61, Senator Sidnor, Division of Correction Release Preparation Program, favorable with 3 amendments.
Recognize the Senator from Baltimore County as the floor leader.
Thank you, Mr. President. As amended, this bill establishes the Volunteer Services Program in the Division of Correction. The division must establish a protocol for registering volunteers in the program to have access to state correctional facilities for the purpose of assisting incarcerated individuals with release preparation. There were 3 committee amendments. The first is technical. The second removed provisions regarding funding from the Cannabis Regulation and Enforcement Fund. And the third renames the program. I move the favorable committee report as amended.
All right, floor leader moves to the adoption of the 3 committee amendments in the favorable committee report. On the amendments, recognize the minority whip.
Thank you, Mr. President. Finance was secondary on this bill, but we weren't able to really have the full experience of discussing it. So I wonder if my colleague would yield for a couple of questions.
Sure. Senator may proceed.
So I see we saw some extensive amendments. Can you describe to me, there's already a release preparation program, correct?
Well, this particular bill, what it was, we had people who were returning citizens who were talking about some of the issues that they've had in gaining access and providing or ensuring that programs were provided and that they were able to provide services for those who are incarcerated. The program is that the Secretary has in the Department of Public Safety and Corrections is called the Lived Experiences Committee. What this bill is intended to do is just essentially to codify that program.
So the department currently has what's called a lived experience program, and the department brings in folks from outside to come in and talk to, that have gone through
Correct.
Experiencing
Yes.
Incarceration.
Right, those who have been incarcerated.
And coming back in. Yeah, yeah.
Correct.
Okay, no, that's definitely a positive. What about this bill is codifying what is a current practice or a current program?
Right.
Right, okay.
Right. In fact, the program in the bill had the support of the department.
Okay, okay. I guess what piqued my curiosity was, and I've been to prison programs before myself in my own kind of personal life, and been a part of. I've been to prison as a guest.
You haven't been as a guest?
I've been there as a guest of my own free will, not of my own free will, and it's important work. I mentioned in the committee, I'm actually rereading a book I read years ago, Chuck Colson's autobiography from the 1970s, I read it when I was really young, and now that I've been in politics, it's been interesting. But he was big on, different programs to help in prison reform in prisons. Anyway, I guess what we're curious about in the bill was that you're going to allow now outside entities to do these programs, and we even specifically have it where people who have been incarcerated before that run some sort of entity can now contract with the Department of Corrections to come in and run the program. Am I identifying correctly that, or is that something already happening and this just codifies it?
It's something that's already happening. Like I said, you have people who are part of organizations that come in, individuals that come in, and this essentially just codifies what's currently practiced.
Okay. Why does the bill allow for there to be not where someone could say they don't want themselves identified? That is a little concerning.
Right. So, and this is publicly identified. So, for whatever reason, they may want their privacy. Maybe they don't want anyone to know that they're coming in and doing the services that they're providing. So, if they're a part of an organization, that organization, instead of putting my name, person A, B, and C, I can say that I'm a part of this organization and put that organization for the public to know. It's not necessarily that the Department of Public Safety and Corrections don't know. They will know.
So the department will know, and there will be a record of it.
Absolutely.
And they will do what I assume they do now, which is conduct checks that it's a person who's in good standing that had a criminal record or criminal involvement.
None of that stuff is going to be changing.
Okay, why would it ever be public? I was trying to understand what we're getting at with that. Why? I mean, would they normally post the names of people on a public website somewhere that are coming into a prison to perform this kind of activity, or?
You know what? That's a good question, and I would assume that under the PIA someone could find out. I'm guessing.
So this will allow someone to, if there's a PIA about who is performing particular tasks and particular services in a prison, the PIA would find the organization but not the name of the person. Is that the?
That would be my understanding.
Okay. Okay. All right. Actually, I appreciate the explanations. Thank you very much.
Thank you.
Thank you. All right. Question now remains on the 3 committee amendments. Any discussion? Any objections? Without objection, the 3 committee amendments are adopted. Question now on the amended report. Any discussion? Any objections? Without objection, the amended report is adopted. Are there any further amendments to the bill or its title? Seeing none, Senate Bill 61 is hereby ordered printed for 3rd reading. Clerk, read the next bill.
Senate Bill 285, Senator Carrozza, Higher Education Scholarships for Correctional Officers, favorable.
Recognize the senator from District 4 is the floor leader.
Thank you, Mr. President. As written, this bill expands eligibility for the Maryland Police Officers and Probation Agents Scholarship Program to include correctional officers and renames the program accordingly. Correctional officers are subject to the same eligibility and service obligation requirements established under the current law for police officers and probation agents. There are no committee amendments. Mr. President, I would move the adoption of the favorable committee report.
Floor leader moves to the adoption of the favorable committee report. Any discussion? Any objections? Without objection, the favorable committee report is adopted. Are there any amendments? Yes, Senator has an amendment.
Thank you, Mr. President. I wanted to offer a friendly amendment.
All right. Page will collect and distribute the senator's amendment.
And this is a technical amendment that ensures that the scholarship also applies to certificate programs and conforms it to the House Cross File HB 852. Hope it will be accepted as a friendly amendment.
All right, let's hear from the floor leader.
Mr. President, I'm still looking for the opportunity to be able to say what many of my colleagues say and resist. However, this one is not that amendment. We accept this as a friendly amendment.
Friendly amendment. All right, senators, move the amendment. Committee is accepts the amendment as friendly. Any objections from the floor? Without objection, the amendment is adopted. Are there any further amendments to the bill or its title? Seeing none, Senate Bill 285 is hereby ordered printed for third reading. Clerk will read the next bill.
Senate Bill 320, Senator Muse, criminal procedure, expungement, no finding, in case terminated without finding, favorable with 2 amendments.
Recognizing the bill sponsor is the floor leader.
Thank you, Mr. President and members of the Senate. This bill expands eligibility for an expungement under Section 10-110 of the Criminal Procedure Article to include a charge for a specific offense for which expungement may generally be granted under current law where a remaining charge was disposed by a court. Number one, disposed by a court with no finding. That's no finding, or included in the case that was designed by the court as having been terminated without findings. Amendment number 1 is technical. Amendment number 2 strikes bill provisions and adds the eligibility provision as specified in the short summary. So I want to move favorable on this bill.
All right, floor leader moves to the adoption of the 2 committee amendments in the favorable committee report. On the amendments, any discussion? Any objections? Without objection, the 2 committee amendments are adopted. Question now is on the amended report. Any discussion? Any objections? Without objection, the amended report is adopted. Are there any further amendments to the bill or its title? Seeing none, Senate Bill 320 is hereby ordered printed for third reading. Clerk, read the next bill.
Senate Bill 346, Senator Waldstreicher, civil actions, violation of constitutional rights, No Kings Act, favorable with 2 amendments.
Recognizing the bill sponsor is the floor leader.
Thank you, Mr. President. As amended, this bill allows Maryland residents to uphold their constitutional rights by providing venue in Maryland courts for claims that arise here in Maryland. There are 2 committee amendments. Amendment number 1 adds definition of a covered officer. Amendment number 2 removes certain provisions, adds the Attorney General as a party that can bring an action, extends the limitations of civil actions under the subtitle, and adds a severability provision. Mr. President, I move the favorable committee report and the 2 committee amendments.
Floor leader moves to the adoption of the 2 committee amendments in the favorable committee report. On the amendments, recognize the minority whip. I'm sorry, recognize the senator from the 37th?
Thank you, Mr.
Senator from
President.
37th on the amendments.
Yeah, I just had a question.
Question for the floor leader. Senator may proceed.
Just to get a better understanding of Senate Bill 346. So the way in its current posture, if it would enable a citizen of Maryland to sue the federal government in state court for an infringement of
their
what?
constitutional rights that occurred in Maryland.
Okay. So would that same citizen have the ability to sue either a state, county, or municipal government?
Not under this law. They would under current law, current federal law, but this bill does not expand that.
So what law would they what law would enable the citizen who it would be able to file a suit against the federal government? What law would allow them to file a suit against a local government or a state or the state government?
It's 42 U.S.C. 1983 is the federal citation.
42, this is the state citizen suing the county, municipality, or state government in Maryland court citing a federal code?
No, they would sue in federal court because it's a federal statute.
Okay, but this enables a state citizen to sue the federal government in state court. And my question is, would a state citizen also be able to sue a state entity or local entity in state court?
They would not, no.
What's the legal rationale for allowing a suit against the federal government in a state court, but prohibiting that citizen from bringing the same action against a state entity in that same state court?
Because for state officers, they already have that right under federal law. We're filling the gap between the two laws.
So isn't this creating a new? What am I? Where this is creating a new avenue for bringing a suit. So why? The question is, why wouldn't you be able to file a claim against a state or a local government for the same violation?
So I'm being told we do allow that under current law under the State Tort Claims Act. This bill doesn't limit that or otherwise change the current law.
And so why wouldn't you sue the federal government under the same regime that you use to file suit against state or local government?
Because there is no law that allows that. That's what this bill does.
Well, I've got some questions about how the disparity in bringing liability or creating liability for state citizens, federal versus state and local. I appreciate you answering my question.
Of course.
All right. Recognize the senator from the 42nd on the amendments.
Thank you, Mr. President. Could I also ask some questions of the floor leader?
Senator may proceed.
This bill was very heavily amended, so I've got some questions to try to flesh out exactly what the bill's about.
Sure.
First of all, why is the bill entitled the No Kings Act?
Sure. So it's to identify the bill as being part of the movement to allow folks to uphold their constitutional rights. One of the most important differentiators of who we are versus who we once were 250 years ago is that people have inherent rights, their constitutional rights, their supreme rights, and we want to provide a venue by which they can uphold those rights.
And is the operative assumption of the bill that federal agents are kings?
Nope.
And who are the kings we're talking about that we don't want to have?
Sure. It's a reference to the style of authoritarianism that we threw off 250 years ago and replaced the whim of one sovereign with the sovereignty of the people, which is the basis of the bill. That sovereignty is provided to them under the Constitution of the United States, and this bill is what allows you to uphold those constitutional rights.
I appreciate that, but who are the kings we're talking about that this bill is going against?
Sure. Again, it's just a title.
It's just a title.
To indicate what we are trying to do in the bill, which is to uphold constitutional rights and indicate how much we value those rights vis-a-vis what we once had.
Okay, let's go to the first operative paragraph, which is section 3-2702A1. It says, an aggrieved party. Now, who in the bill would qualify as an aggrieved party? Would that be any resident of the state of Maryland?
A resident of the state of Maryland whose constitutional rights have been violated, yes.
Okay. It says, so an aggrieved party or the Attorney General may bring an action against a covered officer, which is a defined term, but the term has been amended to some extent. I'm going to read the definition. Covered officer means, except as provided in paragraph 2, an officer who may make an arrest with or without a warrant for violations of the United States Code. So I'm trying to figure which officers have the right to make an arrest with or without a warrant for violations of the United States Code. Do Maryland State Police have the power to make arrests for violations of the United States Code?
In most circumstances, they do not.
How about local law enforcement officers?
In most circumstances, they do not.
Okay, can you identify any Maryland officers who can make arrests for violations of the United States Code?
If they were part of a joint task force.
Okay, and that's a separate exception.
Correct.
That's subpart 2 that was referred to. Okay, so since other than in that limited situation, Maryland officers are not covered officers under the defined term, do I take it that the term covered officer means in almost all situations federal law enforcement officers?
I think that's accurate.
Okay. So the bill provides that an aggrieved party may bring an action against a federal law enforcement officer, not a state officer, just a federal officer, who under color of law deprives the aggrieved party of a right, a privilege, or an immunity secured under the law. Again, a defined term. And again, a term that was modified by the amendment. So as originally defined, law included the Maryland Declaration of Rights, the Maryland Constitution, and the laws of Maryland. Those provisions have all been stricken, correct?
That's correct.
And therefore, all that's left of the defined term law is the U.S. Constitution and the laws of the United States.
That's correct.
Okay. So what this bill does is provides a Maryland resident with the right to bring an action against a federal law enforcement officer who deprives the aggrieved party of a right under federal law or the U.S. Constitution.
Yeah, colloquially, I think that's the correct description.
Okay. Next section says an aggrieved party or the officer of the Attorney General may seek damages and declaratory or injunctive relief. Damages, I assumed, is a term which is defined under current Maryland law, which would include personal injuries and economic damages and non-economic damages up to a cap in current Maryland law, which is in round numbers $950,000, correct?
That's correct.
Okay. And then it provides that a defendant in an action under this section may assert any defense of immunity that was available at the time the cause of action accrued. Since these are federal law enforcement officers, are they going to be in a position to claim sovereign immunity under federal law?
They may, and qualified immunity as well.
Okay. And then it provides the court may also award reasonable fees and costs, including attorney's fees and expert witness fees, to a prevailing plaintiff, right?
That's correct.
All right, we get to the end where it says this section may not be construed to arrogate any statutory waiver of any defense, including immunity. What does that mean?
It's exactly what you were speaking about. The notion here is that we are not attempting to remove any qualified defense, including qualified immunity.
Okay. Now, if a case under this law were to be brought, where would it be filed? Would it be filed in state court or in federal court?
In state court.
In state court. Okay. And would the case be filed against the officer who allegedly violated the U.S. Constitution or the laws of the United States, or the United States government, or both?
I believe it would be filed against the officer.
Against the officer
the covered
individually.
Officer.
Okay. Now, let's divide what's going on from this point into alleged violations of a federal statute on the one hand and alleged violations of the U.S. Constitution on the other, because they're treated differently under the law. So, are you familiar with the Westfall Act?
I am.
Good. So under the Westfall Act, my understanding is that federal employees have absolute immunity from claims arising out of acts they undertake in the course of their official duties, correct?
That's correct.
So if we have a case against them for violating federal statutes, the federal employee that's the defendant in this case, and you said the case would be filed against the individual employee, not against the United States government, would have absolute immunity from claims arising out of acts undertaken by that employee in the course of his official duties, right?
Yeah, that last part that is operative, but yes.
Okay. Then my understanding is that while acting within the scope of his officer of employment is exclusive of any other civil action or proceeding for money damages by reason of the same subject matter against the employee whose act or omission gave rise to the claim. You agree with that?
You're reading the Westfall Act?
Yes, this is actually the language of the Westfall Act.
Got it, okay.
And it goes on to say, upon certification by the Attorney General that the defendant employee was acting within the scope of his office or employment at the time of the incident, any civil action or proceeding commenced under such a claim in the U.S. District Court shall be deemed an action against the United States. So now, I wonder, you said this case would be filed in Maryland State Court?
That's correct.
Okay. It also, the Westfall Act also provides that upon certification by the Attorney General that the defendant employee was acting within the scope of his office or employment at the time of the incident out of which the claim arose, any civil action filed in a state court shall be removed without bond at any time before trial by the Attorney General to the District Court of the United States for the district and division embracing the place in which the action or the proceeding occurred, action or proceeding occurred. So if the Attorney General of the United States were to make this finding, then the case which was commenced in state court would be removed to federal court, correct?
So the premise of what you're saying is that the officer is acting in the course of their duties. What would litigate in this circumstance is that the basis behind the bill is that by violating the constitutional rights.
Well, no, I'm talking about the statutory right, a violation of a statute here. We'll do the Constitution in a minute.
Same idea. By violating the U.S. law, that that officer would not be acting in the course of their duties because they are violating the law. And that question, are they violating the law? Is that violation of the law in the course of their official duties, would be the core question that would litigate in each case.
Well, the Westfall Act simply states upon certification by the Attorney General that the employee was acting within the scope of his office, the case is automatically removed. It doesn't appear that the Westfall Act gives any authority to a state court at all to make a determination. It merely is based on a certification by the Attorney General. Wouldn't you agree with that?
I would not. I think that issue would litigate between the state court and the Westfall Act because the officer is not acting in the course of their duty.
So you're saying that even though the Westfall Act specifically states, quote, upon certification by the Attorney General that the defendant employee was acting within the scope of his office or employment at the time of the incident out of which the claim arose, any civil action proceeding commenced upon such a claim in a state court shall be removed without bond at any time before the trial. You're claiming that the state court nonetheless would have the right to hold on to that case and to make a determination as whether the Attorney General should have issued such a certification?
I believe it'll be a question that the court will answer in each and every one of these cases. That's correct.
Okay. Well, that's an interesting interpretation. I guess we'll have to find out. So let's now move over to the question of a constitutional violation. Now, in a case of a constitutional violation, the Westfall Act immunity doesn't apply to suits brought for a violation of the Constitution of the United States. Accurate?
That's my understanding.
Mine too. So such a suit in that situation would be based on the Constitution itself, which has been interpreted by the U.S. Supreme Court back in 1971 in the Bivens case as providing that there is an opportunity for someone alleging a constitutional violation of the Fourth Amendment to file a suit in federal court for damages, correct?
That's my understanding, yes.
Right. And then there were two other cases in the 1970s which also extended Bivens to cover Fifth Amendment cases and Eighth Amendment cases. Since 1980, no other federal case, no other Supreme Court case has continued to recognize this Bivens theory. So we've now run 46 years without any Supreme Court decisions extending Bivens. Your bill, this bill, the No Kings Act, would make one of these cases available in the case of any constitutional violation, not simply the ones recognized by the Supreme Court way back in the 1970s, but any violation of the U.S. Constitution, correct?
That's correct. As you know, Senator, the Supreme Court declined to extend Bivens, and when they did so, I believe it was Justice Scalia who specifically declined to extend Bivens as judge-made law. The implication is that states and the federal government have the opportunity to extend Bivens through statutory law, and that's what we're doing today.
Okay. So This bill effectively seeks to create by statute a Bivens-type remedy in state court for claims based on violations of rights secured by the U.S. Constitution. Does that sum it up?
That sums it up quite well.
Okay. What about Section 28 U.S.C. Section 1442, which provides for removal of suits against the United States or any agency thereof, or any officer or any person acting under that officer in an official capacity for or relating to any act under color of such office?
So again, a constitutional violation and other violations would not be in an official capacity. When they commit the act that violates the Constitution, the act is that they are no longer acting in an official capacity.
All right. So in order to find this bill, the No Kings Act, constitutional, ultimately the federal courts and all the way up to the U.S. Supreme Court is going to have to find that Bivens is not operative, that a different rule of law will be applied instead of Bivens, which the Supreme Court would have to figure out, which would enable any state, not just Maryland, but the other 49 states, to establish causes of action against federal officials in state court for an amounts of damages which could be unlimited. In Maryland they're not, but they could be unlimited, and you expect that that's what the Supreme Court's going to do.
So I don't agree with your characterization of how the courts will view this, but clearly you are 100% accurate that this case will litigate and there will be a determination as to the constitutionality of these types of laws which are passing throughout the nation.
Okay. Thank you very much for answering.
Thank you so much.
All right. On the two committee amendments, recognize the minority whip.
Thank you, Mr. President. I wonder if the floor leader could continue to yield for additional questions.
Senator may proceed.
So, as I listened to that dialogue, and I think it's very interesting the different ways that this can go from a legal standpoint. I was curious about the task force exemption. So one of the exceptions now in the amendments is that a covered officer does not include a law enforcement officer as defined by 1-101 of the Public Safety Article, acting under the authority of a joint task force that primarily enforces the U.S. Code. Now, 1-101 of the Public Safety Article is basically covers like our police in the state, including county and town police. And I assume some other, there's a list. What is that getting at? So that's saying if a federal officer is involved with a task force, and generally my layman's understanding of a task force is a lot of times it's dealing with drug trafficking or gang activity or all of the above. We're saying, and I'm not trying to be pithy, but are we saying if someone that's a federal officer is involved with the task force and they violate somebody's constitutional rights, allegedly, we have no recourse?
That's not correct. So as you indicated, 1-101 is a list of local and state law enforcement. Mm-hmm. And so we are saying because there is already a remedy for state law enforcement agents that they would be handled under current remedy. A federal officer under your hypo would be handled under the legislation in front of you.
Okay. Oh, because we're saying that you would not then have the state officer be sued under this scheme because there's already a remedy to federal court just because they're taking orders from a federal official, right? Is that fair to say? Okay.
That's correct.
Help me understand this a little bit. I don't want people's constitutional rights to be violated. And I think if there is a violation of constitutional rights, it's reasonable for us to look at ways people can seek just, I don't like saying compensation only because I don't want to make it seem like a money thing.
Sure.
Remuneration. Yeah. What I guess I'm confused by is generally you're going to have someone operating. This bill does not allow you to sue the people in charge who might be ordering something to happen, correct? So I can't go sue the President of the United States under this, correct?
Correct.
Or the head of a department at the federal level?
That's
okay.
correct.
Okay. So how is this going to, if some officer working for a federal agency, and I understand there's one, we've been talking a lot about this session, but there's many different federal law enforcement and federal officials that come in. If they do something and they've been ordered to from somebody higher up, I'm going to be able to sue them when they're following orders. And I understand we have a history of people claiming they were following orders when they weren't, but I'm just saying, how does this work functionally? I understand if there really is a rogue operative, but what the first defense is going to be, well, I was informed by my chain of command that that was okay to do. So, yeah.
Right, right. Under qualified immunity, if they're acting in the course of their duties, they receive immunity in court. And this bill does not change that.
And so if the person that feels that their rights were violated and has some level of proof enough to take it to court says, okay, well, they can't move up the chain then to the sergeant or, I mean, you know, I don't know, depending on the command structure, they can't move up the chain then?
Well, they're allowed, so the suit can be brought against the qualified officer. So it doesn't provide any remedy for the president or agency heads, but qualified officers are covered here.
So if there's a, you know, if it's ATF and they come in and there's an officer that I feel busted down my door and did not do the right things as far as reading me rights or whatever, and he's covered or she's covered under qualified immunity, but their direct superior that ordered it, I can't sue them, or I can if they're a covered officer?
If the person is found to be a covered officer, they can be sued under the bill. But they still, everyone in the chain of command retains immunities under current law. That includes qualified immunity. So regardless of where you are in the chain of command, as long as qualified immunity remains the law of the land, you can offer that as a defense.
Okay. But in this bill, we're only talking about covered officers.
That's correct.
Was the bill before it was amended wider than covered officers?
It was.
So before this bill was amended by the committee, you could sue any particular person that worked for the federal government, or what was the boundary before the amendments, if you don't mind me asking?
Sure. Yeah, so, I mean, if you look at the reprint, you can see the original language, but it was much broader and allowed an aggrieved party to bring suit against anyone under color of law who deprived them.
An individual. I see it.
That's correct. You see it.
So with the amendments, what we've done is said if there is a rogue EPA agent that has seized part of my land, and we find out later that they wrongly were interpreting some part of the Endangered Species Code or the, I remember the old Treaty of the Waters or whatever under the Obama administration that was way out of whack. This bill would have allowed me to sue them, but now I cannot.
In your hypo, the EPA person is not a law enforcement officer, I assume?
No, although they do have, they're not a covered officer, but they were an individual.
That's correct. I mean, you're welcome to bring that next year, but we decided to narrow the bill to cover covered officers only.
Huh. Is there a concern, and should we be concerned, that by doing this, we have a chilling effect on federal operations in the state? And I would suggest before my friend answers the question, because I assume some folks would love a chilling effect of one agency, not me. I like getting illegal immigrants out of the country, but that have committed crimes. Particularly, I think we'd want to get folks who've committed crimes to be deported as quickly as possible when they're here illegally. However, there are other folks in our state there's other activity in our state that we welcome, I think, federal involvement, I hope all of us welcome federal involvement in. Is there a concern this was going to have a chilling effect on, for example, ATF, alcohol, tobacco, and firearms, or the FBI, or I mean, what mitigation do we have against that being like, hey, we're going to take it easier on operations because we don't know if somebody's going to, anybody can file a lawsuit.
Well, so we had extensive testimony on the bill. We had lots of folks testifying throughout the evening. I think it probably went 2-3 hours. No one testified that this could risk a chilling effect on our federal agencies, but you rightly note that this doesn't apply just to one particular agency. It applies to all federal agencies.
Okay, well, so we're not, it's just a lot of, there's so many things here. Because it's so interesting, this bill, because I know we got the title, which is signaling to a particular group of political activists to something which is sort of absurd considering that the party out of power was the one that basically said, we'd love to do vaccine passports, so you can't go to work unless you get a shot, that we now know didn't make a whole lot of sense for what was promised. So it's interesting to me, the No Kings Act, from the people who are now the ones wanting the No Kings Act. But I digress, just a little editorializing on my part. I don't want kings either. I'm glad we got rid of the king 250 years ago, and we're not going back. But it's interesting. It's just very, we're sort of all over the place. So we're basically just saying if you're law enforcement and you violate constitutional rights, not if you're an overzealous FDA inspector or an overzealous EPA investigator. I mean, we've had cases in the western United States where there's some pretty wacky stuff that's happened with people in their public their open private land, where the federal government's come in and tried to control what you can do on your private land. So, and that's happened under multiple administrations of both parties. There's a lot of federal overreach, and both parties are guilty of it. I will say that. I'm happy to say that this is the case. Republicans and Democrats have both been guilty of federal overreach into our rights and our lives. So, with all that said, I wonder if maybe, Mr. President, I think there's some discussion that needs to continue on this, and maybe some amendments to make this a little better. So I'd ask that the bill and the amendment lie over under the rule.
All right, the Senator's motion is in order. The bill and the amendment will lie over under the rule. Clerk will read the next bill.
Senate Bill 397, Anne Arundel County Senators, Anne Arundel County Sheriff, appointment of majors, favorable.
Recognize the Senator from Anne Arundel as the floor leader.
Thank you, Mr. President. This bill requires the Anne Arundel County Sheriff to appoint 3 majors at a salary to be determined by the Anne Arundel County Council. There are no committee amendments. The bill was adopted unanimously. Move for adoption of the favorable committee report.
Floor leader moves for the adoption of the favorable committee report. On the report, any discussion? Any objections? Without objection, the favorable committee report is adopted. Are there any amendments to the bill or its title? Seeing none, Senate Bill 397 is hereby ordered printed for third reading. Clerk, read the next bill.
Senate Bill 514, Senator Smith, criminal law, third-degree assault, favorable with 4 amendments.
Recognizing the chair of the committee is the floor leader.
Thank you very much, Mr. President. As amended, this bill establishes the offense of misdemeanor assault in the 3rd degree. It specifies that the district court has exclusive jurisdiction over 3rd-degree assault cases. It specifies that a person convicted of assault in the 3rd degree is subject to imprisonment for up to 90 days and or a maximum fine of $500. And it authorizes expungement of a conviction for assault in the 3rd degree. Mr. President, there are 4 committee amendments. One is technical. Amendment number 2 prohibits the issuance of an arrest warrant by a district court commissioner if an application for a statement of charges alleges the commission of assault in the 3rd degree. Amendment number 3 alters the definition of offensive contact. Amendment number 4 adds language regarding 3rd degree assault as a lesser included crime of 2nd degree assault. The committee passed this bill unanimously. Mr. President, I move for the adoption of the 4 committee amendments in the favorable committee report.
Floor leader moves for the adoption of the 4 committee amendments in the favorable committee report. On the amendments, any discussion? Any objections? Without objection, the 4 committee amendments are adopted. Question now is on the amended report. Any discussion? Any objections? Without objection, the amended report is adopted. Are there any further amendments to the bill or its title? Seeing none, Senate Bill 514 is hereby ordered printed for third reading. Clerk, read the next bill.
Senate Bill 631, Senator West, corporations and associations, revisions, favorable.
Recognizing the chair of the committee has a motion. Special order the bill to tomorrow.
Thank you very much, Mr. President. I'd like to special order this bill to the appropriate time tomorrow.
Any objections? Without objection, so ordered. Clerk will read the next bill.
Senate Bill 939, Senator Henson, bankruptcy proceedings, exemptions from execution, residential real property, favorable with 2 amendments.
Recognizing the bill sponsor as the floor leader.
Thank you, Mr. President. As amended, this bill establishes that owner-occupied residential real property, including a condominium unit, a cooperative housing corporation that owns the property that the debtor occupies as a residence, a manufactured home, or residential real property of a settler that is held in a revocable trust, is exempt from execution on a judgment up to the following amounts. Number one, $300,000 for an individual who is at least 65 years of age. Number two, $150,000 for any other individual. Beginning October 1, 2027, and every 3 years thereafter, the exemption amounts are adjusted annually based on changes in the Consumer Price Index, the CPI, and rounded to the nearest $25. The bill applies prospectively to bankruptcy proceedings filed on or after June 1, 2026. There are two committee amendments. Amendment number 1 is technical. Amendment number 2 exempts certain property from execution on a judgment as described above. It also allows up to $300,000 exemption for certain property for individuals at least 65 years old, as opposed to individuals who are at least 60 years old and either a veteran or disabled. Move for adoption of the favorable committee report.
Floor leader moves for the adoption of the two committee amendments in the favorable committee report. On the amendments, any discussion? Any objections? Without objection, the two committee amendments are adopted. Question now is on the amended report. Any discussion? Any objections? Without objection, the amended report is adopted. Are there any further amendments to the bill or its title? Seeing none, Senate Bill 939 is hereby ordered printed for third reading. We had two special orders from B&T. We have the floor leader available. Let's start with 557. 557. Clerk will read the first bill.
Senate Bill 557, Senator Bidel, gaming, definition of own, alterations favorable with one amendment.
Recognizing the floor leader.
Thank you, Mr. President. Senate Bill 557 alters the definition of own for purposes of governing the operation of video lottery terminals and conduct of sports wagering. Own does not include having a beneficial or proprietary interest of 25% or less in the property or business of an applicant or licensee if the interest does not confer any voting rights and is held directly by a person or is held in trust for the benefit of a person, provided that the trustee does not exercise any voting rights of control over the applicant or licensee. The committee did make one amendment that reduces the proprietary interest from 25% to 15% or less, and provides that before the transfer of the interest, the application must submit to the commission written notice and certification that the applicant is not disqualified from holding a video lottery employee license and must submit to a criminal history check, which acts as a good guardrail on the piece of legislation. Move adoption of the amendment and the favorable committee report.
Floor leader moves for the adoption of the one committee amendment and the favorable committee report. On the amendment, any discussion? Any objections? Without objection, the one committee amendment is adopted. Question now is on the amended report. Any discussion? Any objections? Without objection, the favorable report as amended is adopted. Are there any further amendments to the bill or its title? Seeing none, Senate Bill 557 is hereby ordered printed for third reading. Let's go to special order calendar number 35. 35. Clerk will read the bill.
Senate Bill 828, Senator Hester, State Finance Delinquent Federal Funds Federal Obligations Enforcement Act. Question is the adoption of the favorable report.
Question is on the favorable report. Recognize the minority whip on the report.
I hit the vote button, not the mic button. My apologies. Mr. President, just to, if we could refresh the body's memory, this bill and this legislation, I'm just pulling it back up, basically allows us to put the state to put a lien on federal property and the federal government if a judge finds, and it allowed the Central Collection Unit to try to collect delinquent federal funds if a judge finds that that the money was wrongly kept. I wonder maybe if I could ask the floor leader to yield for question, just so I make sure I'm explaining it right. But it's we're going to allow the Central Collections Unit to try to collect from the federal government. There's a court proceeding that has to take place.
That is correct. So what this is allowing for is that if a federal court has ruled that the United States was delinquent in payments towards the state of Maryland, we are creating a mechanism for the Board of Public Works to give that information. They have to decide about voting on that. They have to vote for that. And then we move it into the central collection unit to do the collection activity against the federal government.
And so the way that would work at the central collections level would be they would be sending letters, making calls to the head of a particular agency, probably, or the procurement officer of that agency, or
the legislation does not specify, but we would obviously look to the central collection unit to function as they would for any other collection process.
Okay. The words delinquent means more than just late, right? Obviously. But there's oftentimes that there's a lag in federal government paying bills to states or paying their share of something to a state, and just as we, I think at the state level, have had times, I'm sure we've been a little late on certain things. What's the difference between them being delinquent versus just saying, hey, we're in a little bit of a back and forth over a disagreement about verifications or something?
This would obviously go to the court, and the court would determine, would make that determination of the delinquency. So it's not like this would go through the same functions as any other case that would go to the court, and the court would have to make that decision. So it wouldn't just be a late or something like that. I mean, it would have to go through the courts in order to be determined.
Senators, if we could just very, very briefly, before we have a baby totally erupt, we have Kyle Seifring and Kelsey Fung, who have joined us. They were former DLSers who did incredible work at the Blueprint and then left us to go to Washington State, who are now just visiting and back. But we are so grateful to them. And they missed a debate on the Blueprint today, so all those wonderful memories of backroom discussions. So great to see you both. Hope you're both doing so well. And to the baby, whose name we'll have to find out later. Felix, the baby's name is Felix. Excellent. Hello there, Felix. Wonderful.
We could have gotten them on the phone, Mr. President, during our debate to help answer questions. Yeah.
I'm sure they could have helped, actually. Yes. Great to see you all. Thank you all. Great. Thanks. Excuse me. Thank you for that.
No, absolutely. So. The bill doesn't set up, just so I'm clear, the bill doesn't set up, we already go to court over this, right? The bill doesn't set up us, now we can go to court.
That is correct. This does not. This is after, what would occur after a ruling by the court.
Can I ask, and I'm not trying to play gotcha, but how often does this happen?
We're not clear on how often it happens. We're putting together a framework so that we are in a position, if the court does act, to be able to collect.
So this is coming out of, if it's fair to say, this is coming out of the lawsuits that are currently ongoing.
That is correct. And we do know that there are ongoing lawsuits that are occurring. That is correct.
Because the federal government has withheld funds in some cases from states for not complying with certain verification requirements, certain sorts of, there's been questions of whether we're meeting the right goals at times, or whether we're checking people properly, or et cetera. That's the federal government's perspective in this case.
And that's correct. And what this is just saying is that if the state is successful in court, we need to have a mechanism to implement the ruling, and that's what this does.
Okay. Mr. President, I think I've got a couple of ideas to work on this bill a little bit. But I assume we have, I don't know if anybody has any questions. We assume we need to adopt the committee report first, so I do have a couple of amendments.
All right, on the amendments, any discussion of the amendments? Any discussion of the report? Any objection to the report? Without objection, the favorable report is adopted. The Senator has amendments. Pages will collect and distribute the Senator's amendments. So just so we know, we're going to do this, and then one more report, and then one more special order calendar, and then we're going to pause. So. Whenever we're done with this, we have one more special order calendar, and then we're going to pause for the evening. All right. Senator may explain the amendment.
Thank you, Mr. President. There's been a, nationwide, there's been a real surge of reporting on a number of issues with fraudulent enterprises that are draining literally hundreds of billions of dollars from taxpayers around the country as it relates to things like child care subsidies. They just in Los Angeles have found a bunch of hospice things that were draining federal Medicare funds and Medicaid funds. There's been a number of things that are under investigation all over the country. And the concern I think that we've heard from the federal level is high error rates at times on SNAP benefits and other issues. So I think it's important that while we certainly want to have a mechanism to go after the federal government if they're not being fair and if they are just withholding money. But my amendment would just make sure that this bill would not apply to court decisions on federal policies that were implemented for the purpose of preventing fraudulent, wasteful, or abusive practices. So that is the amendment, just to be sure that that we are allowing the federal government to protect our tax dollars when there's a cause for concern of fraudulent, wasteful, or abusive practices. So I would move my amendment, Mr. President.
All right, Senator moves the amendment. Let's hear from the floor leader.
Thank you, Mr. President. I would ask the body to resist this amendment. We would not want to restrict our ability to retrieve dollars authorized by this court by incorporating language into the statute that could be added into any piece of federal policy as unrelated to the condition and would then make it impossible for us to go and get the dollars that we deserve. I would ask that we resist this amendment. Thank you.
Thank you, Senator. All right, on the
Mr.
amendment,
President,
any senators
I'd like
who have
to-
not yet spoken
sorry.
who wish to speak? If not, recognize the maker of the amendment.
I would just ask for a roll call on this amendment. I think anytime change is hard, and there's been a gravy train in the states for a long time because the federal government treated waste as just a cost and fraud as just a cost of doing business. And I hope there's not a lot of fraud, waste, or abuse in the state of Maryland, but it stands to reason there are probably some, because every state it seems like almost every state they're finding a significant amount and not just a little bit. There's always some level of waste and fraud, we understand that, but there's a lot that is being exposed nationwide. So I think we should protect our federal tax dollars when the federal government's trying to withhold them to get to the bottom of look, we've seen that repeat audits we've had in this with the Moore administration. So we certainly hope there's not some widespread issue with SNAP or with other things, but I think it would be better to safeguard. So I ask for a floor vote on this amendment. Thank you, Mr. President.
All right, on the amendment, if there's no further discussion, clerk will call the roll.
Mr. President.
Has everyone recorded their vote? Anyone wish to change their vote? Explain their vote? If not, the clerk will take the call. With 20 votes in the negative, Senator's amendment fails. Senator has another amendment. Pages will collect and distribute the Senator's amendment. Senator may explain the amendment.
Thank you, Mr. President. I wanted to touch base on this issue. I think this would be an important thing for us to be very clear on. If we do recover funds from this, I consider that to be quite fortunate to help us meet state needs. I think it is important to just put a marker down that funds collected under paragraph 1 of this subsection on the bill. So basically, funds collected under this process should only be used to provide services for Maryland United States citizens. And so that's the amendment, just to ensure that we're complying with what is federal law, that U.S. citizens are supposed to be the recipients of federal taxpayer and state taxpayer, particularly federal taxpayer money. So that's the amendment, Mr. President. If it's accepted as friendly, that would be fantastic. I think it's a good common sense amendment. But if it's not going to be accepted as friendly, I would request a roll call.
All right. Recognize the floor leader.
Thank you, Mr. President. I would ask that we resist this amendment. It really functionally is a challenge for it to work. We have a number of people here in our state who are here in varying conditions, but they utilize the services and are parts of our community. They may be green card holders. They may be asylum seekers. Who knows what they are? They're Marylanders. And we want to make sure that we are if we are able to collect and we're able to get those dollars back, that we put them to work for all Marylanders. I ask that we resist this amendment. Thank you.
All right. On the amendment, if there's no further discussion, the clerk will call the roll.
Mr. President,
Has everyone recorded their vote? Anyone wish to change their vote? Explain their vote? If not, the clerk will take the call. With 28 votes in the negative, Senator's amendment fails. Further amendments to the bill or title. Recognized senator from the 35th has an amendment. Pages will collect and distribute the senator's amendment. All right, Senator May, explain the amendment.
Thank you, Mr. President. This legislation gives the state some new, some would say aggressive powers to go after the federal government for money. This amendment simply says we should have simply have a report showing when and how often those powers are used. That way we can tell if this is actually worth it. Through this amendment, a report would show how much money we bring in and also how much we spend to get there. So that way we can tell if this is a good deal or not. Also, we could, potentially there could be lawsuits, and we should track that as well. This bill could lead to legal fights with the federal government, so we should know how many cases there are and how much they cost and what the outcomes are. So it's just kind of looking to a reporting requirement to show, so we can look at those unintended consequences and what the cost is. I'd like to move the amendment, and if it's taken as friendly. Okay,
right.
so it's not going to be taken as friendly most likely, so let's do a recorded vote. Thank
Senator
you.
May, senators move the amendment. Let's hear from the floor leader.
Thank you, Mr. President. Colleagues, as was a part of the earlier debate, it's unclear the frequency that will occur for this, and so it would not make sense for us to do something on an annual basis. Furthermore, the way that this is organized, this is going to go before the Board of Public Works, which is a public vote. And so they will determine what you will see there, the determination from the court case, which is also public, of the feds who are the delinquency that was declared. So there really is not a need for this amendment, and I would ask that we resist the amendment. Thank you.
All right, on the amendment, are there any senators who have not yet spoken and wish to speak? If not, we'll recognize the maker of the amendment.
So, Mr. President, to push back on that a little, if a lot of this is going to be public, it should make the report a little easier to come about, I would think, a little easier to make happen. So I just think having a report to see how this is working, how much money we're spending, and what the benefits are is just a good idea. So I'd like to press amendment. Thank you.
Thank you, Senator. All right, any further discussion on the amendment? If not, clerk will call the roll.
Mr. President,
Has everyone recorded their vote? Anyone wish to change their vote? Explain their vote? If not, the clerk will take the call. With 26 votes in the negative, the senator's amendment fails. Further amendments to the bill or its title? Seeing none, Senate Bill 828 is hereby... Oh, we do have an amendment. I recognize the senator from Howard and Montgomery counties has an amendment. Pages will collect and distribute the senator's amendment. All right. Senator May explain the amendment.
Thank you, Mr. President. Colleagues, this is just a co-sponsor amendment.
All right. Any objections? Without objection, the bill amendment is adopted. Any further amendments to the bill or title? Seeing none, Senate Bill 828 is hereby ordered printed for third reading. All right, last one of the night, Special Order Calendar 37. Clerk will read the bill.
Senate Bill 818, Senator Hayes, State Center Development Contract Plan Requirements and Advisory Group. Question is in the adoption of the one committee amendment and the favorable report.
All right, 818. Question is on the one committee amendment. Any discussion of the amendment? Any objections? Without objection, the one committee amendment is adopted. Question now is the amended report. Any discussion? Any objections? Without objection, the amended report is adopted. Is there an amendment to the bill or its title? I thought there was an amendment for this one, potentially.
I think we're going to special order this to the appropriate time tomorrow.
Okay, all right. Any objections? Without objection, we will special order the bill to the appropriate time tomorrow. All right, we are going to hold there. We're going to hold there. We got a lot done, but we still got a lot left. So tomorrow is going to be another double. This is the first of 3 in a row, so don't want to overtax everybody. Let's see, what is today? Check with committees. Anything for the morning? Any announcements for the morning? Anything before we are on the floor tomorrow? Anywhere? Going once, going twice for the good of the order? All right, if not, let's go ahead and do a quorum call.
Mr. President?
Has everyone recorded their presence? If so, the clerk will take the call. With 43 members in the chamber and a quorum being present, the Senate of Maryland remains in session. Recognizing the Majority Leader.
Thank you, Mr. President. I move the Senate of Maryland stand adjourned until Thursday, March 19th at 10 a.m.
Without objection, so ordered. Have a safe and wonderful evening, everyone. See you in the morning.